First Legal Network for Gender Equity webinar of 2023. If we haven't had the chance to meet yet, I'm Lizzie Vogel, Senior Counsel at the Times of Legal Defense Fund and Legal Network for Gender Equity at the National Women's Law Center. I'm so excited today to hear from our esteemed panelists, who I will introduce to you momentarily. They're here to share with you their collective wisdom about how to use collective action as a complement to traditional civil employment litigation in workplace sex harassment matters. Specifically, these strategies include how worker organizing campaigns can be used strategically alongside civil litigation, how to use the media to tell your client's story and shine a light on unfair treatment of workers, and how to use shareholder derivative litigation to challenge systemic issues of sex harassment. Before we dig in, I want to extend my sincere thanks to those of you who made today possible. So first, our attorneys in the Legal Network for Gender Equity, thank you for being here today and for all the work you do on behalf of survivors. Thank you to our fabulous panel of presenters, Katie Lubin-Benson, Nora Cassidy, Jennifer Reich, and Taylor Sprague. I'm so looking forward to learning from you all today. And finally, my colleagues at the National Women's Law Center, particularly Sky Seeley, Jennifer Mondino, Danny Stewart, and Christina Iriola-Lane, whose work behind the scenes has been tremendously helpful. And now to introduce our presenters. Can you hit next for me, Christina? Thanks. So I'm going to keep this really brief so we can maximize the amount of time we have to hear from them. A longer bio for each speaker is going to appear briefly on the screen, and it was also included with a reminder email that we sent out on January 19th. I'm going to introduce them in the order that we're going to hear from them today. So first we have Tyler Sprague. Tyler is a staff attorney at the National Legal Advocacy Network. NLAN is a legal nonprofit organization that believes in shifting the balance of power towards greater equity through organizing, empowering systematically marginalized people, and challenging entrenched racial discrimination, sexual harassment, and exploitive workplace practices and predatory business schemes. Tyler brings broad experience from before, during, and after law school to this work and to this mission. Next, we'll hear from Jennifer Reich. Jennifer is principal at Reich Law. Jennifer has spent 2 decades in both state and federal court, using creative legal advocacy to defend the rights of workers and advance economic, gender, and racial justice. She's counseled and collaborated with scores of individuals and organizations to challenge systemic discrimination, sexual harassment, wage theft, pay inequity, and other unfair practices in workplaces and other institutions across the country. Jennifer is also currently co-teaching and supervising the gender justice team of students in the UC Irvine Workers Law and Organizing Clinic. Next, we'll hear from Nora Cassidy. Nora is an attorney in Legal Aid at Work's Gender Equity and LGBTQ Rights Program. Legal Aid at Work is a nonprofit legal services organization that assists low-income working families through free legal information, litigation, and policy advocacy. Nora represents and supports workers who face harassment based on their sex, sexual orientation, gender, or gender identity. Through the Central Valley Workers' Rights Project, Nora works in partnership with low-wage workers and community organizations to conduct outreach, education, and advocacy. And finally, we'll hear from Katie Lubin-Benson. Katie is a partner at the law firm of Leaf Cabraser in San Francisco, where she specializes in securities class actions and derivative cases, including litigation against the Boeing company, resulting in a $237.5 million settlement. Katie's also an experienced antitrust litigator. So I just briefly want to go over some housekeeping things before we hear from each of our panelists. So we're going to have individual presentations in the order I just shared. So from Tyler, Jennifer, Nora, and Katie. Then we'll have time at the end for questions, and we'll invite the audience to submit questions through the chat function once the speakers have concluded. And we will read those questions after all of the presentations conclude and try our best to get to everyone. And then just a few other housekeeping points. So this webinar is being recorded. We will share the recording on our website within the next few weeks. Please be sure to make sure that you are muted. We won't be taking questions or comments, like I said, during the presentations, only at the end. And if you have any questions or concerns about logistics, please send them to me or Christina through the chat function on the screen. All right, so Tyler, take it away.
Thanks, Lizzie. Next slide, please. So hi, everyone. Again, I'm Tyler Sprague. I am a staff attorney at the National Legal Advocacy Network, better known as Inland, based in Chicago. Again, as Lizzie stated, we are a legal nonprofit dedicated to shifting the balance of power towards greater equity in our economy and society through organizing, empowering systematically marginalized people, and challenging racial discrimination and sexual harassment and exploitative workplace practices and predatory schemes. Next slide, please. So we do this by working in deep partnership with base building organizations to democratize the law, engage in strategic litigation, and build people power. Inland sees legal action as just one of the many tools available to workers who are organizing for power. In addition to engaging in strategic campaign support, Inland seeks to create a worker-center bar by building, supporting, and mobilizing a national base of lawyers, law students, and legal workers to use legal strategies to support and embolden worker organizing. Next slide, please. Okay, so what I'll be covering today is movement lawyering. What is movement lawyering? What is required of a movement lawyer, and best practices? Next, how to have a trauma-informed approach when working with low-wage workers, and then best practices for working with organizers and low-wage workers. Next, please. Next. Okay. So following this model, I just want to get into what is movement lawyering. So movement lawyering is about using a broad range of strategies to empower people and providing long support for movements transforming oppressive systems, such as white supremacy, patriarchy, and capitalism, and viewing legal support within the context of a broader struggle. So what does it mean to be a movement lawyer? In addition to litigation, movement lawyers are often called up to provide legislative support, policy advocacy, talk to press, educate the community, join strategic conversations, and so much more. At Inland, we view ourselves as both legal support and legal organizers, in the sense that we like to follow the lead of community-based organizations and workers. We try to create capacity for workers to work side by side with worker centers. In that sense, we view our role as finding and recruiting legal resources to support the workers, whether it be law schools, government agencies, following nonprofits, or members of the private bar. Next. So one of the biggest challenges with movement lawyering is the disconnect between law and organizing. Law, as it's taught in law school, focuses on individualized issues and follows a fairly set trajectory, whereas organizing focuses on collective action and has a constantly developing trajectory. This can create a real disconnect between strategies, goals, and timelines. Also, the problem with private law firms, government agencies, and national organizations like Inland is that sometimes we'll get a case without a real connection to the organization or the campaign, and run with the case simply according to the rules of the courts without really considering the bigger picture movement implications. So for example, we've had a discrimination case against a temp staffing agency. The EEOC was interested and decided to litigate, but didn't want the workers to speak about it publicly. So this takes away from the agency of the worker. We can make accommodations on how the case is talked about as lawyers, but at the end of the day, the fight is more important than litigation. Another challenge is that different types of lawyering and a variety of skills are required. Movement lawyering requires much more than excellent legal skills. We also need to be able to draft legislation, do press, opposition research, community outreach, and fundraising. Another struggle is making the case about the process and the road to building empowerment, and not just focusing on the legal outcome or the legal work. Lastly, balancing taking up too much space with the need to take the lead and run with the situation as the subject matter expert. Next. So strategic lawsuits, when and why to bring them. Movement lawyering requires lawyers to identify strategic cases that embolden and move forward worker or organizer-led movements. Still, it's important to note that litigation by itself rarely results in systemic change. As I mentioned earlier, we tend to forget about the bigger picture movement implications as lawyers sometimes. We also take away from the workers when we center the lawsuit. But litigation in conjunction with organizing can make small and large systemic changes. Next. So I want to give an example of where the synergy between law and organizing accomplished more than litigation itself. A couple of years ago, temp workers circulated a demand letter asking for an end to sexual harassment at their company. In retaliation, their company gave them a do not return or a DNR. The temp workers organized a protest at Victoria's Secret on Michigan Avenue, who's a customer of the bottling factory where the temp workers worked in Chicago. The workers took the lead and were supported by a local worker center. Inland and another local legal organization met with the workers, but also brought an Illinois AG representative at the workers' request. The day after the protest and the filing of the charges at the board, the EEOC and the Illinois AG office began its investigation. And then shortly after, the DNR'd workers were reassigned to their jobs. So after a long worker-led struggle, the head of the company actually ended up sitting across from the entire group of about 20 women in the lawyer's conference room. The case was ultimately resolved, but we're pretty sure the company had never expected a group of temp workers to stand up and fight for dignity and respect, but they were wrong. And next. So the bigger picture here is that the outcome was better than what could have occurred in a conservative court. As lawyers, we often have to play by the rules of the court, but workers have a bit more agency to speak up. For this reason, companies aren't afraid of lawyers, they're afraid of workers. Another takeaway is that movement lawyers play the role of not only advocating for the worker they're representing, but keeping in mind the larger goals of the worker center and the campaign. In some situations, organizers won't be able to be in the room. So movement lawyers need to be prepared to advocate for both them and the collective in these spaces. And lastly, process matters. It's not just about the external changes or wins we achieve, but it's also about the process of getting there, because that process by itself can build power or disempower. Next. Next, please. Awesome. So trauma can be experienced in many forms. One can be incident or systemic. So for survivors of trauma, more chances than not, something or someone has let them down, or violated their trust, or just not shown up in the way that they needed. In these situations, it's best to follow the following practices. One, listen to the worker. I mean, it sounds obvious, but it needs to be restated. Believe them, believe their experience. Next, share the process and repeat as necessary. The litigation experience can be really re-traumatizing, and it's our duty to make it as manageable as possible for the workers. Keep tabs on outward sides of trauma and ask for breaks when needed. And lastly, make it empowering whenever it's possible. If there's a choice to be made, present it to the worker. Give them all the info and remind them that it's their decision. Next, please. Next slide. Awesome. So our work focuses on workers in low-wage industries. And we found that workers in low-wage female-dominated industries have the highest reported incidence of sexual harassment and assault by sector. They also contend with low wages, lack of access to business, unpredictable schedules, and retaliatory behavior. Structural elements in low-wage industries that allow cultural objectification and sexual harassment tend to be the norm, which deters reporting and makes retaliation more likely. We believe that worker empowerment and collective action are the best protection for low-wage workers who are being abused, to overcome this trauma of abuse and take action, and then overcome the structural barriers that these industries present. Lastly, we need to be strategic in our work and use a combination of legal and organizing tactics. Sexual harassment is an epidemic, and we can't just litigate our way out of it. We need to coordinate with each other and other worker advocates on the ground to make sure litigation results in something more than monetary settlements, like real structural changes. Next slide, please. Thank you. So these are a couple best practices for working with organizers and low-wage workers. One, internalize the limits of the law. When we focus on it so much, it can be all we see. But as movement lawyers, we mix law and organizing because law alone will not create substantive change. Next, build authentic relationships with the organizers and the community. This requires showing up at protests, working nights and weekends, listening and doing the things that they ask you to do. Understand the model and goals of the organizations you're working with, so learn their strategies and collaborate with them to embolden it. Learn from clients and worker leaders so they know what oppression is. They know their problem and they know their goals. So this is similar to the principle of trauma-informed advocacy. Believe that person had the experience and fight for them in spaces that don't believe them. And lastly, refrain from being a lawyer that says you can't do that. Instead, help them figure out a way to meet their goals. Be creative. Next slide. Thank you. Be self-aware. So recognize your strengths and weaknesses and push past your comfort zone. Go back up and, not take too much space when needed, but also step up as a leader when needed. Earn your reputation. So organizers will make you work for their trust, as they should. So how do you earn your reputation? Do what you say you'll do. Keep your word, be transparent. Next, care about people. Should be obvious, but honestly, sometimes we lose humanity in the work. Make time for frequent reflection. So evaluate what has been done and if it's effective, not only the results, but again, the process. Develop and maintain healthy coping mechanisms to deal with all of the above challenges until we have better solutions. And lastly, build community. When times are hard, we have community. It's about longevity. And I think that's it for me. Thank you. I'll pass it to you, Jenny.
Great. Thank you so much, Tyler. So I am, as Lizzie mentioned at the front of the call, of the webinar, my name is Jennifer Reich, and I have my own practice here in Oakland, California. I spent a long time, more than 8 years, serving as the legal director for Equal Rights Advocates, which is a frequent co-collaborator with NWLC. And I've been doing class action and non-class employment and civil rights litigation for my entire legal career. And today I'm going to talk to you a little bit about how we can apply some of the movement lawyering principles and approaches that Tyler just talked about to gender justice litigation, and talk about the ways in which you can and should be looking for opportunities to integrate and deploy litigation strategies in collaboration with worker-led organizations that will enhance and really augment the goals and campaigns and efforts of those organizations and coalitions, while also strengthening your litigation. Next slide, please. So, whether you're in private practice or in nonprofits, there are a lot of ways that you can work with and allow worker-led organizations and coalitions to inform your approach to cases. from the beginning to the end, whether it's case selection or your litigation strategy, to lift up your clients' voices and their stories, and to amplify the impact of your legal victories and settlements. These are all ways in which, working, I have found that it is very well worth the time and effort to work with worker organizations where that is possible, not only for you and for your client's sake, but also for the sake of our communities and the society that we all are seeking to make more just. And I have had experience working with worker coalitions and organizations and unions in all kinds of gender discrimination cases, including those relating to sexual harassment, pay inequity, and pay and promotion discrimination, as well as pregnancy accommodation and discrimination. So in the next 15 minutes, I'm going to try to provide a few pointers and concrete examples of how this can be done at all these different stages of litigation, and why you can and should be doing it in more of your cases. Next slide, please. So before a case is filed, you obviously there's a lot of ways in which a case might come to you as either a private firm or a nonprofit. But by paying attention to what's happening and forming relationships with worker organizations, such as worker centers and worker-led coalitions, you can really you and your staff can help to identify cases that involve issues that are really common or problematic, or opportunities to bring cases that might actually advance an ongoing campaign or effort to organize in an industry or in an area, an issue that you care a lot about. It can also, by working with worker centers and having relationships with worker-based organizations and coalitions, can help you find plaintiffs and identify targets for litigation. If there's a defendant that really needs to be sued because they're really acting badly, and also if there are workers out there who really want to speak out and are ready to take on a public fight, that can be a really important way to do that. Also, through your relationships with worker-led organizations and reaching out to worker groups and centers and coalitions, you can really get an inside view of what's going on in a particular industry or with a particular employer, and find out more about the norms and practices there. And also that can help you identify really credible and trustworthy experts, both to again, inform how and where you might file a case, as well as, helping with the litigation along the way. And it also gives you a bigger picture so that when you do come across a client or a group of clients who you're actually going to take legal action for, it places those clients' experiences and their claims into the broader context. Next slide, please. So at the outset of the case, as I said, working with worker-led groups can help you identify plaintiffs and defendants, and it can also help you frame the case narrative, really tell a story. As litigators and attorneys, we know that we need to think about the story that we're telling and who is telling it from the very outset. So identifying workers as storytellers and figuring out the protagonists of your story and the antagonists, really helping you make the client story actually not just about holding a particular employer or institution accountable for the wrongs done to a particular person or individual, but also about, make the case about the need to stop and fix the kind of harmful practices that are causing the systemic inequities and pervasive unfairness or unfair conditions that brought the case to you in the first place. Also, in terms of working with worker centers and understanding what ongoing campaigns might be happening, if the case raises issues of first impression or might bring the opportunity to enforce a new law, it can be important to know those things, because it could affect which court you file in, even which city or county or state you file in. And And remember also that, as Tyler was pointing out, sometimes we might file a case or a charge that we know is likely not to win. And maybe we know that there are some causes of action that are very likely to be dismissed. Or maybe there's a statute of limitations that has expired and the grounds for equitable tolling are really weak or non-existent, but we might want to bring those claims anyway, not only because doing so is going to increase your client's sense of agency and empowerment, and therefore may be important to their overall sense of seeking accountability, and healing, but also because doing so, just filing those charges or that complaint could play a role in a bigger fight and address, help to move the needle on a bigger issue in which your client has an interest and or in which she may be really deeply invested. And sometimes losing a battle can actually help you win the war, because it could help to draw attention to issues and problems as well as gaps in the law that make all of these things difficult to challenge or dismantle. And also doing so, we can sometimes, just in filing a case or initiating litigation, can help to generate media attention, which of course is going to be discussed by a later panelist. But that in itself can also get the attention of lawmakers, elected officials, and others with decision-making power or influence. It also, another, I think, advantage or opportunity presented by working with worker centers and organizations is that it really encourages you to be bold and creative in your demands and your prayer for relief. A typical lawsuit might ask for, compensatory and declaratory and equitable relief, but most of the time we plead these things in very general, non-specific terms. And, maybe we go as far as asking the defendant to do something or to stop doing something that in order to comply with existing legal duties. But worker-led organizations can help you really identify the specific policies and practicey changes and the conditions that really need to be changed in order to redress and address the harms that form the basis of the lawsuit. And I just would also say that I find that in working with organizing groups, that it really encourages me to reject the sort of scarcity mindset and binary notions of what's possible. Instead of framing things as either or, it really encourages me to embrace a both and to recognize that sometimes what will right a wrong to a particular individual will also make things better for others in the long term. So during litigation, working with worker centers also allows you to put principles of trauma-informed and client-centered advocacy into practice. For example, as Tyler just talked about, part of trauma-informed advocacy is about recognizing that the litigation experience itself can be very challenging and sometimes even re-traumatizing. And the process of how you litigate a case can be as important and impactful for your client as whether you ultimately win or lose. So connecting clients with supportive community members and resources is a way that lawyers can make litigation more empowering for our clients by connecting them with other workers who will understand what they've been through and can help them feel really supported and heard and believed. And sometimes even help them channel their anger and their grief and their sense of being wronged into positive action by engaging them in mutual support efforts and by cultivating them as leaders and activists and spokespersons. And I've seen this happen, and hopefully we'll have time to tell you a little bit about that in later slide. Again, that's one of the main things that I would encourage people to think about. And of course, as I mentioned before, working with worker-led organizations can help you to generate media attention and bring more pressure to bear on defendants. And of course, it can also be an opportunity to educate the public about the issues in your case. Next slide, please. Yeah, next slide. Sorry, I think I was talking about that last slide, but I'm looking at two different things. I'm sorry about that. And finally, at the end of litigation, or when you are in settlement discussions, then that's where at the beginning, middle, and end, your relationships with workers organizations can be really important, because the worker-led organizations can not only help you identify the policy and practice changes that are needed and what type of monitoring might be appropriate and really get involved, they can also be involved in the solution itself if you negotiate a role for them in the dissemination or implementation or monitoring of compliance with non-monetary relief. So, as I'll discuss in a moment, non-monetary relief, also known as programmatic or injunctive relief, is something that I've successfully negotiated and that many other litigators have negotiated as part of settlements, not only in class actions, but also in individual and group cases. I think it's a really important way in which you can engage with worker organizations. I'm going to actually talk a little bit about a couple of examples of this. So if we move to the next slide. So Browner versus Covenant Aviation Security was a case that I worked on when I was at Equal Rights Advocates. I co-counseled with two private firms on that case. That it was a case that we actually settled. We brought and settled sort of simultaneously. Effectively, we negotiated a class settlement pre-suit. And we were able to work with a union that represented, this was a case brought on behalf of TSA workers at the airport who were being denied accommodations and forced off of work during their pregnancy. And so we worked with a union that represented airport workers at both the front and the back end of this litigation. And since it was the third time that we'd heard from someone who'd experienced these issues at this company, we decided to investigate whether a pattern or practice existed, and if so, to find out what the source of the problem was. Working with the union, we were able to conduct some Know Your Rights presentations and trainings. We met with workers, we spoke with union representatives and worker leaders, and not only had the opportunity to educate them about their legal rights, but also to learn what kinds of issues people were facing with respect to accommodation and disability. And that's how we were connected to another woman who then became our second named plaintiff. So speaking with the union not only helped us identify the sources of the problem, all the different policies and practices that were going on, but also helped us figure out where we were going to find evidence, what kind of documents, what universe of documents looked like that could help us establish what those policies were and practices were, and how many others were affected by these policies and practices. And then in turn, we offered to, and were able to help the union and members of the union understand more what the law actually required when it came to pregnant workers' rights and the company's obligations. And that in turn strengthened their ongoing organizing efforts and helped raise the bar in their collective bargaining and contract negotiations. So throughout the case, which as I mentioned, settled pre-suit, we kept in touch with the unions to let them know what was happening and hear about the issues that workers were facing. And it also helped that one of our two plaintiffs was actually still a current employee the entire time. Next slide, please. Some of the non-monetary relief that we got in that case, which I list here on the slide, really was informed by the information that we learned and the collaboration that we had with the union throughout that case. So there were a lot of significant programmatic and policy changes that the company agreed to, and they were very much shaped by and strengthened by our relationship with the union, including in terms of how employees were going to be notified of the settlement and the rights and procedures. Next slide, please. So the next sort of case study is actually a tale of two cases. It's because I've litigated a number of them that have to do with the pervasive problem of sexual harassment and violence in the janitorial industry. And I'm just going to talk briefly about two of them, which both involved individual non-class claims, and both led to some very significant changes, not just with the employer in question, but also that were really intimately connected with the movement to end rape on the night shift and to address these issues. So, as briefly background, workers in the janitorial industry are extremely vulnerable to sexual harassment and assault. Women in particular tend to be paid the least and are generally stuck in the lowest ranking and non-supervisory positions. most of the women who work in the janitorial industry are non-white, are women of color, and many of them are undocumented immigrants, as well as their male counterparts. And the whole industry, their employment is often very precarious due to the whole industry being like highly fissured with lots of layers of contractors and subcontractors. So they and on top of all of that, they often work alone at night and in decentralized work sites where they're largely invisible. So you know, we know a lot about these issues in large part due to the organizing campaigns and research and reports and worker education efforts that have been carried out by janitorial worker organizations. And so if you advance to the next slide, please. So the first case that I wanted to mention is Bojorquez versus ABM, which was a case that was filed back in 2010 and eventually went to a jury trial in April and May of 2012. Our client was a 43-year-old monolingual Spanish-speaking immigrant woman and a mother. She was harassed and also raped, sexually assaulted in an office that she was cleaning by her supervisor during her work shift. And within a few months of reporting it, she was let go. And so the charge, you know, was filed in May of 2005, and for a long story that I won't get into, was not actually concluded and then filed in court until 2010. And, you know, what I would note is that at this time, you know, we didn't actually have, when I was working on this case, both as in private practice and then at Equal Rights Advocates, the union that represented the janitorial workers was really not very cooperative or supportive. Leadership at that point didn't really recognize sexual harassment as a major problem. And they were also, I think, fearful because we were seeking to hold the company liable for the actions of a foreman who was basically classified as a lead worker and a member of the same bargaining unit as our client. But at the time, what was really inspiring was that at the time of trial, there were members of this burgeoning local grassroots organization called MUA, Mujeres Unidas y Activas, who heard about what was going on and showed up at trial to bear witness and show their support for our client. And it was really awesome. And in the end of the trial, we won an $812,000 verdict, and most of which was emotional distress, and the company appealed. But in the meantime, next slide, please. After the jury rendered that verdict, our client, who's pictured here on the left, really felt heard and believed, and she started to be interviewed by the press and speaking publicly about her experience. She ended up being featured in a documentary called Rape on the Night Shift, which came out in the summer of 2015, shortly before we actually reached a settlement in her case. And at that point, you know, what her coming out and speaking in that documentary did was it really lit a fire under this movement of workers. And so really it was that summer when that movie started to be screened in communities and people started watching it, the union started showing it and talking about it, that the movement, the sort of battle cry and movement of Ya Basta, which is Spanish for enough is enough, was born. So next slide, please. So by early 2016, immigrant women workers were leading an effort to make sexual harassment protections a centerpiece of their union contract negotiations and legislative advocacy efforts. The union voted to make it a strikeable issue. People took to the streets. Worker survivors staged a hunger strike at the state capitol until Governor Brown actually signed into law the bill that had been co-sponsored by members of the Ya Basta coalition. Next slide, please. And meanwhile, the Ya Basta coalition members and worker leaders just kept building the movement. They were forming groups of promotoras who were janitorial workers who served as educators and advocates to lead the culture change work from the inside out and the bottom up. And more legislation was introduced and signed into law, including a law that requires janitorial employers to provide industry-specific worker-led and survivor-centered sexual harassment prevention training. Next slide. But meanwhile, in spite of all this incredible organizing and education and advocacy, it didn't put an end to the problem, especially in areas that were unorganized, where there was no union representation. So in about 2017, we got involved with another case involving 3 janitorial workers who'd been harassed and assaulted in Central California. Next slide, please. And in 2018, together with a private law firm in Fresno, we filed a lawsuit, and with the support of the Time's Up Legal Defense Fund and the janitorial workers and worker leaders of Yabasta, we proceeded to litigate that case. And this time, the worker organizations, the union workers and leaders, the members of the Yabasta Coalition, they were with us all the way. They came to the courthouse and they stood behind, literally, physically behind our clients when we spoke to the press about the day we filed the case. They met with our clients afterward. We watched sort of solidarity being built. Our clients felt supported, they felt encouraged, they felt really kind of emboldened to demand change. Next slide, please. And I'm almost done. I know I'm a little bit behind. So when it came time to settling that case in late 2020, early 2021, we really this time were able to negotiate super robust non-monetary relief. And I failed to mention that part of the relief we got in the Bojorquez case did include some policy changes that actually affected all of janitorial workers in California. Even though our client at the time of settlement of that case had not worked for the company for over 10 years. But it was because of the media attention, because of the growing movement that was burgeoning at the time, and that by 2020 was really sort of very, very much out there. It was because of that energy and the knowledge that there were workers who were watching that we were able to get that relief. And then we were able to build on that and really push for changes that went way beyond sort of compliance-oriented changes in our settlement of the Sanchez, the second case. And I just put some of the examples up here. I don't have time to go into any great detail, but I'm happy to answer questions about those things and what they were in more detail if we have time in the Q&A. But next slide, please. I think that the important lesson that I want to say is that over the course of that litigation, I really was incredibly moved to watch our clients going from really being victims to survivors to agents of change. In the course of that case, one of our clients, left an abusive partner. 2 of them applied for and obtained their visas. They became more and more comfortable speaking publicly with the media about their stories. And they really also found their voices and really were able to tell us what they needed to see change in their industry and in their employer. So with that, I will wrap up late and pass the mic to Nora, I think is next. Thank you.
Hi, everybody. And thank you so much, Jennifer and Tyler, for all of that information. And I just really want to build on a lot of what Jennifer was talking about with using the media as part of litigation and just as part of legal advocacy as a whole. My name is Nora Cassidy. I use she, her pronouns, and I am an attorney at Legal Aid at Work. We're a California-based nonprofit advocating on behalf of low-wage workers. Next slide, please. So we often use the media in our cases to give clients a platform for their voice to be heard, to create broader-based change in the industry, to pressure an employer to come to the table, and to raise awareness about the conditions that low-wage workers are facing. And so we do use media when there has been no litigation. So for instance, our wage protection program just last Friday was involved in a CBS News report raising awareness about their client who has been waiting for a hearing from the California Labor Commissioner, which is our state agency in charge of enforcing laws, including the minimum wage requirements. And so our client's been waiting for over 3 years for a hearing. And she was featured in this story talking about these delays and how it was so difficult to get justice through the agency right now. And media like that can be really helpful in creating focus on these systems that are under-resourced and not functioning as they should, and convincing the powers that be to allocate more money and create resources and fix these problems. And then Christina has kindly put that article into the chat. And then we do also use mediation after litigation. So I want to highlight one of our clients, Helen James, who was dishonorably discharged from the military in the 1950s during the Lavender Scare. Helen was a member of the Air Force, and in 1955, the subject of a very aggressive investigation that revealed that she is a lesbian, and she was promptly dishonorably discharged. And Helen, unfortunately, is one of thousands of LGBTQ service members who were dishonorably discharged prior to the repeal of Don't Ask, Don't Tell and its predecessor policies because of their actual or perceived sexual orientation. And these discharges led to these folks being alienated not only from the veterans community, but also oftentimes from the LGBTQ community as well. So once Don't Ask, Don't Tell was repealed and the government created a procedure for service members to upgrade their discharges when they had been dishonorably discharged because of their sexual orientation, that information really hasn't gotten out to folks, and people aren't even necessarily aware that this is a right that they now have, again, in part due to that alienation from the violation to begin with. So Helen was fighting to get her discharge upgraded. We eventually had to file in court. And after the government did upgrade her discharge to honorable, making her now eligible for veterans benefits along with other remedies, Helen started speaking out, will continue to speak out about her experiences. And because of her willingness to speak out about what happened and shine a light on this issue, we've received a lot of calls from similarly discharged LGBTQ veterans who we've helped to upgrade their discharge. And we're also now pursuing advocacy to upgrade these discharges on a larger scale. But this outreach and knowledge about how pervasive it is and folks hearing about it is really possible thanks to Helen's willingness to come forward and be such an advocate. So if next slide, please. I also want to talk about mediation during litigation or litigation because of mediation. So we, Legal Aid at Work, along with Lang, Richard, and Patch, are currently representing a client, Laura Zuniga. She is a long-haul truck driver based out of Fresno, California in the Central Valley. And she was sexually assaulted by her co-driver while they were on the road, and she reported to the dispatcher and called 911, and then was immediately fired and did not receive her final paycheck. And so Laura, I've been representing Laura for over 2 years now, and she has been clear from the beginning that she really wanted to speak up about what happened to her and to not only hold the company accountable, but to work on creating industry-wide change and to ensure that this does not happen to other folks. And so Laura's goals really informed our advocacy. We wanted to support her in speaking out, and so we did apply to the Time's Up Legal Defense Fund and received for press assistance, and were fortunate enough to be paired with Maria Patrick, the Director of Media at the National Women's Law Center, who's been an incredible partner in promoting Laura's story as she wants it to be promoted. But then we also filed a lawsuit in Fresno Superior Court because we are well aware of the defamation claims that sexual assault survivors now are facing when they come forward and speak about what happened to them. And so we chose to create a very detailed complaint that we filed in court to better protect Laura's storytelling and advocacy for herself under the fair reporting privilege, as she would now be describing and talking about what is written in a judicial proceeding in her complaint that is filed in court. And so that was a main driver of filing when we did. And after we did that, then we started working with Maria. An article was published in The Guardian and in Forbes magazine, which is screenshotted on the next slide, please. But right now, I would like to move ahead to an interview that I did with Laura just last week in anticipation of this panel, because I thought it would be much more helpful for you all to hear directly from her about why she wished to speak with the media, and if that's been working and what that experience has been like. So if you wouldn't mind skipping ahead to that video, and I'll just summarize afterwards. Thank you. I can't hear it.
Sorry, let me try again.
Hi, my name is Laura Sanchez Zuniga. I'm 40 years old. I'm Hispanic. I'm a mother of 3. Have 7 cats, 1 dog. I'm from Mexico. And I'm trying to live the American dream in America. I decided to talk to the media.
Sorry about that.
I'm Hispanic. I'm a mother of 3. Have 7 cats, 1 dog. I'm from Mexico. And I'm trying to live the American dream in America. I decided to talk to the media when I felt frustrated. I felt cornered. I fell into a depression. I felt like nobody was listening to me. So I decided to speak up because I felt like I wasn't the only one that went through this. I felt like I was just put aside, and the company really didn't care. And I knew I needed to speak up, especially having 3 daughters. I don't want them to be victims. I want them to speak up. And before I didn't speak up, I used to be very quiet. Whatever my boss would say, I would do. But from this, I said I need to speak up. Because if something happened to my daughter or a friend, especially being a female, I want them to speak up, not to be quiet. I needed to speak up, not just for me, but for other people that are being quiet and are probably embarrassed to talk about this, because it is very, very uncomfortable being in this situation. That's when I decided that I needed to speak up. My goals is to bring awareness to the situation in the trucking industry. There is no, when this happened, there was no protocol. I was just let go of my job. I wasn't paid my final paycheck, and I didn't know what to do. And my goal in media is to get attention and maybe change the laws and get other people to help people like me and to get other people to speak up. I feel like I'm not the only one that has been in a situation like this, and a lot of people stay quiet because they don't like to fight. I'm not saying they don't want to fight, but like fight physically. I'm saying like they don't want to fight. Like me, I'm not a fighter. I usually stay quiet. I don't like confrontation, but I felt like I needed to speak up because I felt that this was unfair. And this shouldn't happen to me or to anyone in the future. And it needs to stop. And I feel the media has the power. People have the power to make changes.
So you've already had your story published in 2 national outlets, The Guardian and Forbes magazine. How has it felt to see your story out there in the world for people to read and to learn from?
In a way, I love it, but in a way, I feel, I don't know, but probably people gonna say, why did she go into the trucking industry? But in a way, I love it more because people are gonna read my story and they're gonna help people like me and maybe get other people to speak up of something that happened in their life and maybe get the encouragement to come forward and to speak up. That's my goal, and I was overwhelmed when excitement when that opportunity came. I actually forget about it sometimes, but I love it. I love it.
So we, of course, also filed a case in court against your employer, but at the same time, we have been going to the media and you've been telling your story. Have you gotten something from the doing press and the media that you have not gotten from your case proceeding in court?
Yes. With the media, I feel like I have a voice. When I was reading the articles that I spoke up, I felt that was me, and I was speaking up, and people were reading my story, and I was being heard. In the court system, with all the legal, I feel like I'm not being heard. Like I'm just being a side, and nobody really cares. And I just want my story out there. So I will be grateful for any attorney to help someone like me make a difference in somebody's life like me and my daughters. Because it's not just me. I have responsibility of my 3 daughters, and I have responsibility of my mother and my cats and my dog. So if I go down, my daughters are going to go down too. My cats are not going to eat. And my dog is probably going to be the same way too. And my mom's going to be impacted too. So I encourage attorneys to help people like me. I'm very grateful for Nora and for the people that she worked for, because I have not given 1 cent, $1, and it's been over a year. And Nora is still with me, more than a year, probably 2 years. And I'm very grateful. Thank you.
Thank you, Christina. If you wouldn't mind going to the preceding slide, I just wanted to point out that I think that yeah, as Laura's highlighted, this case has been going on for a while, and while we don't have a resolution yet, in the meantime, Laura's goals of being able to speak up and talk about what happened to her and hopefully propel the trucking industry to better practices has already been happening. And so there isn't that same lag that we often experience with litigation. And of course, the media can be less lawyer-led. And, Tyler and Jennifer have spoken about ways for attorneys to really take a back seat in litigation and have a more client-centered approach. But with the media, we've experienced so far that there's just less of a filter and there's less of Laura speaking through somebody. And instead, if you have a chance to read the Forbes and the Guardian articles, I think you'll really hear her own individual voice coming out as it just did. And so I will leave it there, and thank you very much.
Hi, everyone. I'm Katie Benson. I'm a partner at a law firm called Leaf Cabraser, Hyman and Bernstein. We have offices in a couple of places around the country. I practice out of our San Francisco office. And I'm here today to talk about something a little bit different, but hopefully related, is shareholder derivative litigation. So I am a securities lawyer. In most of my practice, I represent shareholders in public companies in actions against the company or its officers and directors relating to securities fraud, and in particular, a type of securities claim called a shareholder derivative case. If we can turn to the next slide. So briefly, I'll explain what shareholder derivative litigation is, because I think it's different than what I understand most of the attendees are doing in your day-to-day practice. So shareholder derivative litigation is where a plaintiff shareholder seeks to pursue a case against the directors and officers of a company on behalf of the company itself. So in this instance, the shareholders step into the shoes of a company and seek to sue the company's own directors and officers for some harm that has befallen the company as a result of the director and officer misconduct or failure of oversight. So why would shareholders do that? There's a couple of instances where we see it happening historically in these types of cases. One is egregious behavior towards consumers or employees, health and human safety, or massive fraud cases. So where the company itself is engaging or engaging in certain activities, and the directors and officers don't take steps to remedy that, fix the problems within the company. When they don't do that, the company ends up harmed, damaged, shareholders can lose value, and then they want to pursue claims against the directors and officers. Generally, you see this come up in instances where directors and officers of a company are aware of wrongdoing, what's called in the derivative parlance red flags. So red flags of risks or wrongdoing within the company, yet they fail to take steps to remedy it and to fix the problem. Next slide. One of the really interesting things about shareholder derivative litigation is that it's not just monetary resolutions or settlements that shareholders are looking for in these instances. In many cases, some of the most potent settlements out there are those that achieve non-monetary relief or structural change. We've heard both Tyler and Jennifer talk about that as a goal of their work, and that's a huge part of what shareholders are doing when they're pursuing derivative litigation. In particular, I'll note in the when the derivative litigation relates to underlying employment misconduct, most often in the cases we've seen so far, sexual harassment, sexual abuse, and also sometimes discrimination. So in the employment context, what we'll often see is that there'll be a pervasive culture of sexual harassment or abuse at a particular public company. And oftentimes you'll also see that certain directors or officers, the CEO of the company, high-level executives are themselves engaging in the harassing behavior. In those instances, the directors of a company have an obligation to step in, remedy the problems within the company, force out those that are engaging in that activity, and really transform the culture. Unfortunately, in a lot of public companies, we don't see that happening. Many companies are focused primarily on profits, which of course is something that the shareholders like, but we also recognize, and shareholders recognize, that it's important that the company is not otherwise harmed by misconduct or illegal behavior that's occurring, whether it's with respect to workers, employees, or the company's consumers, for example. So I'm going to take just a couple of minutes and talk through a couple of exemplar cases that have happened. These are recent cases. Shareholder derivative litigation has been around for a long time. It's traditionally been focused on the types of misconduct that I talked about before. So a good example, one of the cases that I was recently involved in was a case against the Boeing directors for their failure of oversight relating to the development and sale of the Boeing 737 MAX airplane, which two of which tragically crashed and caused the deaths of hundreds of individuals. So that's a more traditional route for a shareholder derivative case. And what's interesting is that we've seen over the last 5-6 years, the proliferation of additional shareholder derivative cases that are related to employment misconduct. So those that I'll talk briefly about today are a Wynn Resorts case out in Nevada, a Google case in California, a case relating to Fox News, and a very, very recent case that's still pending relating to McDonald's. As I talked about briefly, the one of the primary goals of derivative litigation is to institute changes as part of a settlement. So when a derivative case is resolved, it oftentimes includes major changes to corporate governance that are meant to improve the conditions for employees, consumers, whatever the harmed group was, moving forward. And each of the cases that I'll talk about today did institute those types of reforms. So the hope, of course, is that not only are you improving the company by holding directors and officers who fail to properly oversee the company accountable, but you're also creating new mechanisms and structural reform within the company so that you don't see the same problems happening. Or if something does happen, it's caught more quickly, it's dealt with, and the company culture overall becomes a better place to work for employees. Next slide. So the first successful case was a case relating to Wynn Resorts. And briefly, in that case, the CEO of the company, Steve Wynn, was a notorious sexual harasser and engaged in really a long-standing pattern of sexual harassment and abuse of Wynn company employees. The evidence in the complaint or the shareholders pled that the directors were fully aware of Steve Wynn's conduct and took no action to prevent it, stop it, and hold him to account. So it continued for many, many years. And according to the shareholders, the board's attempt to conceal that misconduct by the CEO put the gaming licenses in jeopardy. And obviously, if you are running a casino, as Wynn Resorts was doing in Las Vegas, not having a gaming license is going to be a problem for your company and the ongoing success of your company. So this case was resolved, ultimately settled in Nevada, and met final approval in 2020. And that had, and the settlement included requirements that the company and the board institute a number of changes. I've summarized them here. There was an overhaul of employment practices and training. A new compliance program was established to oversee and address problems with sexual harassment were they to appear moving forward. There were also requirements to increase the board's diversity. It was not particularly diverse prior to that. So new board members with different backgrounds and experiences. The hope, of course, is that board members that have had different experiences are going to bring to their oversight those experiences and be more attuned to identifying and responding to whatever the harm was, in this case, ongoing sexual harassment and a culture of concealing that harassment. They also instituted the Rooney Rule, which is a requirement, I believe, that came out of the NFL that requires the interviewing of certain diverse candidates before making decisions on employment, and a prohibition on non-disclosure agreements and forced arbitration clauses. So prior to this, when employees were required to engage in arbitration for certain claims that they had, that was done away with as part of this resolution. So a lot of these are very significant corporate changes, corporate governance changes that came about because the shareholders pressed for this in resolving the derivative litigation. Next slide. There was another case in California against Google's directors and officers for similar types of conduct. In that case, shareholders alleged that the Google directors were essentially covering up sexual harassment and discrimination at the company. A key fact in that case was that the Google directors had allowed several high-level executives at Google to leave the company with significant severance packages, even though those executives were leaving the company precisely because they had engaged in a pattern of sexual harassment. So the board knew that they had to go. The board severed the relationship with those executives, yet paid them multi-million-dollar severance packages. That's something where the shareholders saw that and thought, that's not the type of oversight that we're looking for from our board. These are individuals who not only have to leave the company, but should do so without the benefit of their very generous stock packages, especially for a company like Google. That case resolved also in 2020 out in California. This one had an interesting element to the settlement, which was that the company itself agreed to devote $310 million in funding for DEI-related initiatives at the company that included the creation of a diversity, equity, and inclusion advisory council and workplace group, again, with the goal of overseeing and ensuring that marginalized groups felt lifted up and recognized, and that they could raise their voices as needed to address wrongdoing, whether sexual harassment, discrimination, or otherwise. There was also a sexual harassment and fiduciary duty training for the board so that they were fully aware of their responsibilities with respect to overseeing executives and the company. And also, again, as we saw with the Wynn case, elimination of a mandatory arbitration for certain employment claims and a limitation on non-disclosure agreements, allowing employees to talk about their experience at the company without fear of the company coming after them. Next slide. So the last case that specific case I'll talk about today is the Fox News case. I'm sure a lot of folks remember a couple of years ago, there was a lot of press surrounding an ongoing culture of sexual harassment and abuse at Fox News. That came from the top. The CEO of the company, Roger Ailes, was engaged in harassing employees, in particular, certain on-air personalities, including Gretchen Carlson, one of the reporters, and that Bill O'Reilly, another on-air personality, also engaged in harassment of female employees. So beyond these individuals' conduct, there was also a general culture of harassment, discrimination, that subjected the company to lawsuits by former employees, including Ms. Carlson, as well as a number of regulatory investigations. So that case was actually a pre-suit resolution that was reached. So before the shareholders filed a complaint, they went to the company, discussed the possibility of resolving these claims and instituting governance reforms that would improve the company. And that ended up being, that was brought to, in this instance, the Delaware Chancery Court for approval. A brief aside, sometimes with shareholder cases, you see a lot of references to Delaware and Delaware law. That's because the law governing a shareholder derivative case is the law where the company is incorporated. And the vast majority of companies in the United States are incorporated in Delaware. And those that aren't, normally those state laws look to Delaware law. So really it's a Delaware law that's guiding a lot of these claims and ultimately the resolution. So in the Fox News case, There was also this Fox News, there was a workplace professionalism and inclusion council that monitored hiring and advancement, had various anti-harassment and discrimination initiatives, as well as a complaints process to allow employees that experienced harassment or discrimination to raise it to ultimately to the board. And Bill O'Reilly and Roger Ailes both had departed the company at that point. I'll just spend 30 seconds talking about a recent decision that was in the news that folks may have seen, relating to McDonald's. So at McDonald's, there was also a party culture, a culture of harassment, led in large part by the former CEO of the company, as well as, if you can believe it, the head of HR, who engaged in harassing women employees at the company over a number of years. And just recently, last week, a Delaware Chancery judge, again in Delaware because McDonald's is a Delaware corporation, upheld shareholder claims against the directors, as well as this HR, the head of HR, for allowing this culture of concealment, a party culture, a culture of harassment to continue at McDonald's, and for allowing the CEO and the head of human resources to depart the company with significant severance packages, notwithstanding their known harassment of employees. So that's a recent case. It hasn't yet resolved. I wouldn't be surprised if resolution of that case included corporate governance reforms intended to improve the company moving forward. But I think what's interesting about seeing these recent matters, and again, they've all happened in the past 5 or 6 years, is that you see application of the shareholder derivative model and shareholders being really focused on the fact that this type of wrongdoing harms the company, and that there's a way to hold directors and officers accountable for that, and also to implement reforms moving forward that are going to improve the company for employees. So my hope is that we continue to see more of these, and that companies sit up and take notice and understand that this is an additional way that, or an additional tool in the toolbox that worker lives and employee lives can be improved. Thank you so much for having me here.
Thank you so much, Katie. And thank you to all of our speakers. That was really fantastic. I know I have a lot going through my mind right now, and I want to just talk about all my takeaways, but I will hold back and turn it over to the Q&A as promised. If you have questions, please feel free to add them to the chat. If they're directed to one of the specific panelists, please feel free to note that in your question. And Jennifer, would you like to get started with Andrew's question in the Q&A?
Sure. And just in case folks didn't see it, Andrew had posed a really good question. He had asked, and maybe, I don't know, just so we all know, and I know, Andrew, if you wouldn't mind, where are you practicing? I'm just curious, like where you're coming from, where you're practicing, if you want to post it in the chat or something. But Andrew Edelman asked, how do you effectively raise claims that are unlikely to succeed for purposes of client agency and advocacy, et cetera, while avoiding the risk that the other side will file for sanctions against you or assert a claim for fees or use it to a disadvantage to your case or your clients? And I said that was a great question. And, I think obviously, when you're using, one of the things about doing sort of trying to incorporate movement lawyer and trauma-informed advocacy approaches into your litigation. Clearly at the outset, you're going to have a conversation with the clients and with any sort of outside collaborator organizations that you might be, working with or coordinating with about the real limitations, right? Of the law in general, but of the legal system and the risks, and make sure that your client understands both the risk and opportunities presented by bringing a, maybe untested claim. I mean, clearly, nobody wants to invite Rule 11 sanctions. Nobody wants anyone to put something, clearly you should, you have rules of professional conduct and ethics that would prohibit you from, bringing a frivolous claim. And, that is certainly not what I was implying. But, there's always sort of litigation at the edge, right? I mean, where you're trying a new theory. It's a different, maybe you're asserting that there's a pattern or practice of discrimination, and it's a certain type of pattern or practice that, you haven't found a whole lot of case law that said that, oh yeah, that's a cognizable injury. Well, I mean, you have to use your creative skills and sort of push, right? And that's where sometimes, maybe you do get dismissed. Maybe that cause of action is dismissed, or a motion to strike those allegations or something is granted. I mean, there's a real difference between something that gets dismissed or something and something that is actually considered sanctionable. So clearly you want to stay on the non-sanctionable side of things because you don't want to invite that kind of counter-offensive or open up the door. But, as Nora was pointing out, there's so many ways in which, victims of gender discrimination and harassment and other kinds of discrimination and harassment are in fact already facing sort of the weaponization of defense techniques, whether it's, frivolous, frankly, defamation claims or other kinds of counterclaims. Plenty of low-wage workers face those in litigation all the time. And so it's something that I think you have to incorporate into your upfront conversations with the clients. And also, if you're collaborating with a worker group or, you want to make sure that what you're doing is going to be supportive of some sort of campaign or organizing effort, it absolutely, it's not always going to be a black and white thing. And again, I think by utilizing some of the client-centered approaches, but really being clear where, you as a lawyer have knowledge about what the rules are and what the consequences of, being adjudged to have broken one of those rules could be, to make an informed, to help your client make or clients make really informed decisions about the risks that you're willing to take. And you also, of course, have every right to say that as attorney, I am willing to go this far and to do this much, but I'm not going to stake my, my license or my professional reputation for integrity on it. And, I think that, that's, I guess, the best way I could say it, but maybe Katie or Nora or Tyler would welcome your thoughts on this issue.
Thanks, Jennifer. I'm actually gonna, if it's okay, I'm gonna move on to the next one. And so thanks, Erica. This is actually one of the questions that I hoped would get asked, so I appreciate this. So Erica says that Erica is in Idaho and not aware of local worker centers or worker-led organizations beyond unions, which are also rare in Idaho. So how would you suggest that Erica get connected with the right groups to do this kind of work? And I thought maybe Tyler, you could start us off, and then Nora or Jennifer, if you want to jump in with anything else.
Yeah. I guess I'm not sure if I can contribute in terms of finding local worker centers, but I guess in the event that you're interested in still doing stuff beyond Idaho, maybe broaden your network by introducing yourself to like outside worker centers and worker-led coalitions who are movement oriented. I would consider joining national listservs as well. Maybe participating in virtual roundtables and then just like looking at other outside volunteer opportunities. There's also organizations like Inland that are actively like engaging practitioners throughout the country and, engaging or connecting them with volunteer opportunities. Like for example, we had a worker center bar project that we created last year that was designed specifically to increase legal resources and support low wage workers And we just kind of sent that out nationally and said, hey, if you are in any of the following states, if you're interested in doing intakes, or Jenny, I think actually you attended one of our clinics. If you're interested in providing feedback on intakes or know your rights materials, or just providing research materials, we would love to have you. So one is I think just doing a little bit of research and getting added on those listservs that are campaign oriented. And then the other I think is finding organizations like Inland who are actively trying to create spaces for you. I'll stop there if anybody else has
Before you
anything
jump
to
in,
add.
Nora, I was just gonna say, Tyler, or if anyone has specific listservs to recommend and wants to pop that in the chat, I think that could be super valuable for Erica and others who probably have the same question.
Sure, yeah, I'll do that.
Yeah, I just wanted to raise that I have honestly faced a similar problem here in California because I'm practicing in the Central Valley, and most of the worker centers that California is famous for are going to be in the Bay Area and Southern California, and there's less worker organizing here, at least through formal worker centers. So one thing we did is we actually applied for a grant and hired a community organizer to be on our team to be able to do that even harder work of going out and finding communities where they are, and because they're not going to be labeled, worker center or something like that. But folks are organizing their communities. It's just a matter of actually finding them, as you point out. And we also just are really conscious about always asking people what are their goals in talking to us. And oftentimes it is to improve the working conditions of me and my coworkers or my former coworkers. And so the workers who we're speaking with themselves can be a catalyst for this kind of organizing effort, not led by an outside worker center, but we've had workers, come bring all of their coworkers to a talk with us and things like that. And so we really look to the workers themselves for that leadership.
Thanks so much. We are at 4:29. Christina, I'm going to ask you just to put up the last page of our slideshow. I'll just leave this in the background for folks. And then if people have a couple extra minutes to stay on to answer these next few questions, that would be fabulous. But I also recognize that the time is concluding. So what is up on the screen right now is, if you're interested in following us on social media, please feel free to do so. And this is also information about joining the legal network, which Christina put in the chat as well. And thank you to all of you who are adding awesome suggestions of organizations and listers in the chat. That's super, super helpful. If our speakers have 2 more minutes, I will throw out the last 2 questions. But for those of you who need to log off, totally understand. These questions are great. So from Anonymous, how do you ensure that various groups are on the same page or have power in decision making in terms of goals and strategies, whether it be between a union, lawyers, employees generally, or shareholders? That is a great question. Anyone want to jump in with that one?
Go ahead. Yeah, go ahead, Katie.
I was just going to say, first of all, I think events like this, where we're connecting with people who are doing the different type of work, are really important. And that kind of cross-pollination of the different types of advocacy that are happening, keep not staying in our lanes, right? Being connected to each other about that. One of the things I'll just say, in our experience, when we're representing shareholders and we're thinking about, what types of reforms can happen. One thing that's great to do is we're looking for the input of experts in the field, whether they are, other lawyers or they worked in that particular business, the folks that are studying these issues, advocating on these issues, speaking out in the press, et cetera. We want to connect with those people because we want to ensure that the types of reforms that we're talking about with the company and the directors are actually going to be meaningful and they're going to be effective. And If I'm not someone who's worked at that company and I don't have kind of detailed experience with the experience that those workers have, it's going to be more challenging for me to craft something that makes sense and it's going to make a difference at the end of the day. So it's something that we look for, but again, these types of panels and events are really, really important to move that forward.
Did anyone else want to jump in before I go to Daniela's question? All right, so we'll end with this one. So do you have any suggestions on how to get national attention to a local worker issue? I practice in a small state with some big issues, but given its nature as a small state, it's difficult to get support even from local news outlets when the perpetrator is one of the largest employers in the state and feels untouchable. Nora, you want to start with that one?
Sure. So with Laura's case, one thing that we did was just try to figure out what national conversations her story could fit into. So, she is a frontline worker in the pandemic. Also, trucking became a huge issue that was in the press. And so we were looking for these hooks of conversations that are happening, the anniversary of the Me Too movement, to get that national press and feed into the conversations that are happening and offer journalists like a very, practical and specific example of what they wanted to talk about, and then hopefully use the fact that we have this national coverage to then get more local coverage, including in a media environment that might be a little less worker friendly and less amenable to, having a big story about sexual assault of female long haul truck drivers, for instance. So that's one small suggestion.
I would just quickly piggyback on what you just said, Nora, and also just to pick up on something that the question mentioned, that this was one of the biggest employers in the state. I mean, I would think that when you have a big employer like that, there is probably, there are some reporters in the state, some journalists who, have written about that employer in the past, or might be interested in the angle, in a different angle in terms of, if that employer has some connections to state elected officials or perhaps is a state or a federal contractor. There could be different approaches that you can and sort of reach out to those journalists who have covered that employer in the past and say, there's a darker side here, or there, whatever. And we, you can offer journalists like an exclusive, and sometimes they might want to do that. So even if there isn't like a particularly newsworthy event that can be like the hook for a press announcement or release, you can sometimes cultivate the media's interest sort of sideways, and then get the issues heard perhaps in a different way. But I was also going to say that there are national groups that do advocacy on different issues that, then themselves may have contact with local worker centers and worker organizations, or community organizations that support workers in that area. So, if the issues, for example, have to do with workplace safety and health, there's the Coalition for Occupational Safety and Health, or the Council, the COSH, and they have local affiliates. There are a lot of, other worker organizations, not just unions, but worker organizations broadly that are kind of organized by industry. So it's sometimes you can go national first in order to find some local connections.
Thanks, Jennifer and Nora. And I just want to make a quick plug for the Times of Legal Defense Fund, because we do provide media assistance to, if the case falls within the scope of what we do, so workplace sexual harassment or retaliation. So Nora mentioned that we help support Laura's case of the media assistance that they sought. So if that is something that you think might be relevant to you, you can absolutely reach out to me. I at the email that I sent all the reminders from, and I'm happy to give you more information about that. So I'm gonna wrap us up there for because of time. But I just want to first thank our fantastic presenters, Tyler, Jennifer, Nora, and Katie. You've given me a lot to think about, and clearly all of the other attendees who have just asked really fabulous questions. And it's great to see you all engaging in the chat. Thank you so much for that. Thank you to all of you who attended today and for your active participation. And again, feel free to follow us on social media. And if any of you who are tuning in are not part of the legal network, feel free to check out our website to learn more about how it works and to join it if you are interested in doing so. And thank you again. And I want to confirm we will be sending, so the recording will be on our website, and we are also able to send out these slides to you, and we'll do so in the next few weeks. Thanks so much, everyone.